Today we're here with Manijeh Moieni. She is an estate planning specialist with National Bank Financial. Today we're going to be talking about power of attorney agreement. I would like to talk to you about power of attorney agreements. How important is it to have a power of attorney, number one, that you trust, and number two, that is competent? What are some of the issues that can arise?
Some of the same issues should be considered with respect to powers of attorney as with your selection of your executor.
Okay.
Except that in the case of a power of attorney, the stakes may be higher because you're still alive. You need someone who knows how to take good care of you.
Right.
A lot of times we think of people who we trust for a power of attorney, but trust really has two elements. One is the character of the person. Mm-hmm. The other is their skills.
Their ability to actually administer.
And their ability may be limited by just the fact that they have 3 kids.
Right.
Or they have a full-time job or a new baby. So you want someone who can take care of you while you're still alive, but unable to take care of your own affairs. So the same considerations apply. And I usually suggest that the clients may want to also consider a professional power of attorney or a trust company as power of attorney. Okay. And they can do the same. They can name a child or a couple of children together with this professional or a trust company to bring in the family perspective, but the trust company or the professional will carry the burden of the work that needs to be done.
Okay. We're talking about power of attorney agreements. Is there any drawback in naming, oftentimes, say we have a family and they have 2 children or maybe 3 children? What are the complications when you name all 3 of those children or 2 of them as power of attorney? What happens? So
in powers of attorney, you have one of the problems is the following. You have a choice in powers of attorney to determine whether your attorneys can work together or separately.
Right.
If you say they work together, then with all of the decisions, they have to be together.
They have to be in agreement.
They have to be in agreement, but also sometimes they have to be present physically at the same time. If things have to be signed that require original signatures, or someone feels like they need to have a meeting with the attorneys, then everybody has to be there at the same time. That may be desirable if kind of safety is an issue, security is an issue, so that one child isn't just doing things unilaterally.
Railroading the others or something like that.
Exactly. Yeah. If you say they can work separately, that can also be problematic because all 3 of them can be in different parts of the city, different parts of the country, and do all these different things legally.
Sorry, so you can actually say they have to work together or they can do it separately. You can
say they have to work together or separately. You have that choice.
I didn't know that.
Yeah.
You learn something new every day.
So that's one of the issues with naming like 2 or 3 kids. But of course, the issue with naming one child is that, again, that child has to carry all the burden, is under pressure. A lot of estate planning is like life. It's a balancing act. Yes. You have to consider the pros and cons and decide what suits you best. And with respect to a choice of executor or power of attorney, there is a third solution, and that's naming a corporate executor or a professional, which would do away with a lot of the other issues that can come up.